Good afternoon, everyone. It is the 6th meeting of the year for the Bankruptcy Bar Association, and today we have Steve Elmer, who's going to talk about 722 redemption issues. He is from 722redemption.com, and they do a lot of funding for collateral being redeemed. Next month we've got Student Loanify coming. So they'll be coming and talking to us about the portal that they've been managing, and that applies to anyone who has a student loan, whether or not they're filing a bankruptcy. Essentially what it is you direct the individual to that website. They'll upload all of their information, and we'll give them what is available to them, including options if they are inside of a bankruptcy. So Steve.
Thank you, sir. Hi, my name is Steve Elmer. I'm corporate counsel for 722 Redemption. As Jonathan mentioned, we provide funding for people to redeem their automobiles in bankruptcy. There's a few other programs we also offer, but I was here to discuss basically the redemption process and from an automobile standpoint. Again, thank you for letting me come. This is it's a nice building, by the way. You guys have it pretty nice here. I was a debtor's attorney in Indianapolis before I joined 722, and I've been with 722 for about 7 or 8 years. And we didn't have a lounge next door. That's pretty nice. So I'm a little jealous of that. Might have stayed on the debtor's side if I was there. Well, not that I'm not on the debtor's side, but stayed representing clients. And if anybody needs it, I have my spreadsheet, my PowerPoint over there. So if anybody needs a copy of it, I didn't pull it up, but I have printed all copies of the PowerPoint. One of the big things I like to start with is, and this is a preliminary matter, but Section 1325 does not apply in a Chapter 7 redemption or a Chapter 7 bankruptcy. It only applies in 13s. So what I mean by that is the 9-10 rule for a cram down, which is what you do in a Chapter 13, does not apply in a Chapter 7. So if you're looking to redeem a client's car, doesn't matter if they bought the car a year ago, and it's within 910 days, they can still redeem it in a Chapter 7 bankruptcy. I'm sorry. Oh, okay. I was going to say, yeah, feel free to interrupt too. I usually start with that. Sorry, that's on me. Feel free to jump in if you have any questions. But we used to handle probably 15, 20 conferences a year. Now it's a few less. And everyone I'm asked, what about the 9-10 rule? What about the 9-10 rule? So I like to bring that up. No 9-10 rule. Now there is a little bit of a timing issue. I've seen some cases where if you file the Chapter 7 bankruptcy, if the client purchases a vehicle and then 3 months later files a bankruptcy, I've seen judges say, well, it was an arm's length transaction 3 months ago, so the only depreciation is 3 months worth of depreciation. Now, pretty rare, doesn't arise a lot. I still recommend trying the redemption because it's up to the creditor to fight it if they want to, but we can get into that. So as you guys know, there are 4 main options in a bankruptcy. You can surrender the vehicle, give it back to the creditor, and sorry to get a little basic, but I just kind of want to run through everything. You can reaffirm on the vehicle, keep it as is, and then you can redeem it, which is what I'm going to be talking about. And again, I'm going to focus more on the automobile standpoint, solely because that's the industry I work in. That's where I think most of the objections arise as well. Especially, clients are going to have stuff that they got from Rent-A-Center or refrigerator or something like that. Typically, you don't get a lot of objections on those. Automobiles, you do. So I'm going to focus on Section 722 from the automobile standpoint. Obviously, there's a retain and pay option. Depends on the jurisdiction. It sounds like down here you can retain and pay, but that depends on the creditor if they'll allow it. Obviously, if they won't, creditor can come pick up the car. A lot of that depends on if the ipso facto clause is enforceable, which I believe in Florida it is, which means basically the filing of the bankruptcy means the client defaulted on the contract, so the creditor can go and pick up the automobile. So who qualifies for redemption? Has to be a Chapter 7 debtor that has a personal property item secured by a lien. So personal property, not real property. Typically underwater, cross-collateralized, And I like to point out the cross-collateralization. Attorneys don't often think of redemption, or they think, oh, if you have a loan or multiple loans with a credit union and an automobile loan with a credit union, just surrender the car. Redemption's an option. They can redeem it because it doesn't matter what they owe the credit union. All that it matters is what the car's worth. So if they owe $30,000 to the credit union and the car's worth $10,000, they can redeem it for that $10,000. Now the credit union might object, and we'll get into that, but you can still redeem it even if it is cross-collateralized. Now the big catch, obviously, with Section 722 is they have to have the lump sum ready to pay the creditor. So they have to have the money ready to go. So if they owe $20,000, car's worth $10,000, they have to have that $10,000 ready to go. That's where companies like mine come in. There are other finance companies. A lot of them are local or regional, but they can usually borrow the money. And we'll get into some of how that works, but I'm going to talk more specific about the redemption process as a whole. So some of the benefits of redeeming. Typically, if they finance the car, so if they use a company like mine or another redemption company, they lower their payment and they have a shorter term. I know that's how we operate, that's how most redemption companies operate. We have to either match the term and lower the payment, or we don't offer our services. So we'll do a comparison between the reaff versus the redemption. If we can't help them, we don't offer our services. If they're behind on payments, redemption could bring them current, obviously, and I'm talking again if they finance, it would bring them current. Maybe they converted from a 13 to a 7 and the creditor won't let them reaffirm on the vehicle. The redemption would bring them current, so that wouldn't matter if they couldn't reaffirm. So they're underwater, they converted, behind on payments. This is another way for them to keep that car. If they want to trade the car in 3 months down the road, they can. They're not underwater on it. So I think that's kind of an underrated benefit of it. It's not like you're looking at locking this client in on keeping their car if they redeem it. No, they could trade it in down the road because they're not underwater. They don't have that negative equity anymore. Gap insurance, they no longer have to pay for that. And finally, if they do finance it through a lender, it helps them reestablish credit. Most finance or redemption companies will report to credit agencies, so it kind of can help them get back on track. Additionally, what I've seen with the lenders we work with, if the client makes 12 on-time payments, the creditor will lower the payment, or lower the interest rate, I'm sorry. So if they make 12 on-time payments, they call in, say, hey, I made 12 on-time payments, the creditor will lower their interest rate.
What's your interest rate?
It'll range from 10% to 23.99. If it is that 23.99, though, it still has to save them money. So it still has to make sense from, like I said, the redemption versus the reaffirmation. So even if it is the higher amount, it still has to be a savings there. And I put this chart on there, and you'll see I've been presenting on this for since I started 7 or 8 years ago, and I need to update my car. I have a 2008 Chevy Impala on there. Sorry?
Surrender.
Yes, that's probably a surrender, or pay cash to redeem that one. I wouldn't even qualify for our program anymore, to be honest. But if it had 21,000 miles, so it's not a bad car, though. But you'll see this template here, or this graph that shows the reaffirmation versus the redemption. And as you'll see, the value of the vehicle under the reaffirmation is blank because it doesn't matter. For the redemption, that's all that matters. What's the value of the car? And in this case, the term was lowered by 4 months. The payment was lowered by over $100. And it looks like they saved, and this was an actual case, it saved them about $7,900 redeeming on this versus reaffirming. Or, obviously they can surrender it too. That's an option. But it's good to kind of know everything they can do. And in this case, a redemption did provide substantial savings. Just need to update the car. So the actual section of Section 7, or the actual code Section 722 states, an individual debtor may redeem tangible personal property intended primarily for personal, family, or household use. So it's an individual, personal property, and it says for family or household use. So again, no real estate and no business. Can't redeem a business asset, but that's a little iffy because, you know, as you've seen probably a lot of times, or a lot of clients, you know, if they have a little LLC or some little business, they might title the vehicle in both their name and the business name. They can still redeem that vehicle. I haven't seen it being an issue. At the end of the day, I mean, the creditor's not going to fight on that. And it's still titled in their personal name too, so. Depends on your creditor. Well, that's very true. We were just talking about that. Some jurisdictions, there are just creditors that dig in and fight on everything. They don't care how much it's going to cost the finance company they're representing. They just want to try and make a point of it. I haven't seen that as much of an issue down here in Florida. St. Louis, we were talking about, there's a couple creditors' rights firms there that fight. There's a couple in California. Here, I mean, because we work nationwide, so I kind of get a broad understanding of it all. Credit unions are a pain, and we can discuss that, but they're a pain in everything, so that's no surprise. So the specific statutory prereqs are an individual debtor, tangible consumer goods securing dischargeable consumer debt, and property that has either been claimed exempt by the debtor or is abandoned by the trustee. And that's not typically a huge issue down in Florida. You'll see some jurisdictions, they actually require the debtor's attorney to file a motion having the trustee formally abandon the car as an asset. It's pretty rare. Like I said, California requires it. I think Iowa requires it. You know, there's a few here or there sporadic that do. Most of the time, as long as you've gone to the 341 hearing and the trustee's filed his report of no asset, even if he hasn't, you're still fine to redeem. And again, I don't know why they would make you claim it as exempt. It's an underwater asset. I've never quite understood that, but it's also, that issue only arises in certain jurisdictions, and here's not one of them, but I like to mention it just in case you see something like that. You never know, you get a new judge or somebody changes. One of the big areas I really want to talk about today is valuation. And the reason I want to talk about that is that's where the issues arise. That's where the objections come up. That's where creditors fight. They're gonna hope for the ceiling. They're gonna claim the car's full NADA retail value. Nothing's wrong with it. It's, you know, the debtor's taking great care of it. We all know that's not the case. We know these clients. So no offense to them, but they probably haven't taken care of their cars like they should have. So before 2005, the retail valuation was just 506A1. And 506A1 said this: the claim is a secured claim to the extent of the value in such property. Such value shall be determined in light of the purpose of the valuation and of the proposed disposition of the use of such property. So let's go into what that means. That meant, back before 2005, wholesale or liquidation value. Courts looked at it and said a redemption is a functional equivalent of a surrender of the automobile followed by a public liquidation auction at which the debtor appears and yada yada yada. Creditors couldn't object. This is great. So they looked at, you filed a redemption motion. The valuation purpose at that point then was liquidation, because that's basically what the client was doing, was surrendering the car. It was kind of the heyday of redemptions. Sadly, that day changed with a lot of stuff in 2005. But it's kind of a side story, but when the law was changing, we're based in Cincinnati, and at one point we had a good amount of employees, and we were working with our state reps there to try, because we were actually worried they were going to get rid of Section 722. It's a small section of the code. Some of you have probably never or haven't filed a redemption, especially involving the vehicle. We had to actually work with our representatives to try and fight the automobile lobbyists. And they called us one day, this was prior to me joining, but called and said, sorry, there's nothing we can do. The law is going to change. The car creditors were paying attention on this. The creditors were paying attention, and they had obviously more firepower than anybody. So they weren't able to get rid of Section 722 entirely. They just changed the standard, the valuation standard, that is. So they added 506A2. And that says such value should be determined based on the replacement value of such property as the date of filing of the petition, without deductions for cost of sale or marketing. Replacement value shall mean the price a retail merchant would charge for the property of that kind, considering the age and condition of the property at the time value is determined. So 506A2, replacement value, replacement value went to retail value then. So it went from auction value or liquidation value to retail value. So replacement value for the property, for property acquired for personal or household use is defined as the price a retail merchant would charge for property of that kind. So from auction to retail. And that's a great case, by the way. If you're looking for the basics of redemption, if you have more questions after today, that's a great case to look up out of California. It has a great rundown of the process of redemption. I mean, there hasn't been a lot of new cases over the last few years that I've seen anyway. That one's from 2008, so it's post-2005. Runs through the process of valuing the car, runs through the process of filing redemption. It's a good standard. I like that case. It's not a terribly long read either if you're bored one day. So they said the code still failed to articulate a specific method. So how do you determine what a retail merchant would charge? And again, I'm going to bore you guys a little bit on this retail valuation. It's just, like I said, it's what I see in my day-to-day. I see these objections. I see these creditors fight on valuation. In determining the replacement value of an automobile, the retail value of an identical make, model car is a starting point, with certain expenses, including mileage, reconditioning, and the retail cost of repairs as allowable deductions. So you start with retail, same make, model, and then you can take into account the retail cost of repairs. Now, this can get a little tricky because you'll see those outlier cases. We had a couple, one was a guy had this truck that he loved, and he had put all this money on his dashboard. He put these flames, and he had put all this stuff on there. I guess, I don't know if he had put money into it, and they were arguing that the car is worth more. And but in that case, you're looking for a specific buyer. I mean, I'm not looking for a truck with flames on my dashboard. And I think at that point we were able to argue, and we successfully argued that it's. I mean, that's right. Just because he necessarily put money into it doesn't mean it's an improvement. Doesn't mean it upped the value of the vehicle. We had another one. Sadly, we didn't get to see this one through. I think we resolved it early, but we had somebody that had a van that was handicapped, and they'd gone through a credit union, and they had cross-collateralized all these other loans on the van to make it handicap usable, and they owed. It was a lot of money. I could see why the credit union was fighting on that one. We were, again, we were arguing it's a limited market, but sadly we didn't get to see that one through to figure out who would have the successful argument. I tend to see their point a little bit because it probably does up the value of that van. I mean, there are fewer buyers, but we did not get to litigate that one, unfortunately. So, as you'll see, I quoted that Morales case again. And as it says, you start with the Kelley Blue Book, the NADA, based on what a retail merchant would charge. But again, that doesn't include the cost of sale and marketing. So you start with that, and then the code allows a deduction for age and condition. Kelley Blue Book doesn't. It might allow it, but something. So what you'll see when a creditor objects is they're going to say the car is worth full NADA, full Kelley Blue Book, and that's not what the code says, and that's not the case. It's something like 2% of cars meet their excellent condition or their top level condition. It's very difficult to actually meet that, and the creditor is going to say, "Oh yes, this car is worth $20,000. It's in pristine condition." That's not the case, and it's one of the more difficult things I see is some attorneys, they're just not willing to fight the creditor on that. It's really not even that much of a fight because you can basically show X, Y, and Z is wrong with the car. You don't really need testimony. It's really just as easy as a couple of emails to the creditor that shows this. Not every case. You'll have hearings. But a lot of times, like groups like mine, we can provide you with the evidence you need to rebut what they're saying, that it's worth this full retail value. Again, the burden is on the debtor, burden's on your client to show any deviation from that starting retail valuation. They can provide testimony, declarations, advertisements. That's one of the things I used to like to do when I was in private practice. I would go and see what is a retail merchant out there charging for this vehicle? What is on the market right now? Is there anything similar? Again, you could take into retail cost of repairs, but at least like to get an idea of what's out there. It's an easy Google search, Craigslist search, something like that. So again, NADA and Kelley Blue Book are not always accurate, as they think, as they kind of look at cars as perfect. And there's another case I cited actually from the Southern District of Florida, Ortiz here. And it says, you start with the retail value, you subtract the retail cost of repairs. That's the standard. Use those declarations. Use your client's help. Use companies like mine, our help. We'll go through the valuation with the client. We'll start. You might file the petition. You might get a basic understanding of what the car is worth. But what we do is we'll talk to them and say, has this car been smoked in? Is the windshield cracked? Does it need new tires? When's the last time the brakes were replaced? We get a more general idea of what the car's worth because we know what those costs are. We've been doing this for a long time. So we'll start with the retail valuation and then we'll ask them those questions. And then we'll provide you with the value of what the car is actually worth based on what a retail merchant could charge for that vehicle in that condition as it sits now. Valuation date. I like to mention this. It's just kind of a weird section of the code. A lot of it can be a little weird, I guess. But A2 states the replacement value should be calculated as of the date of filing the petition. But the second sentence states that the replacement value should mean the price a retail merchant would charge at the time the value is determined. So this is kind of a little bit of an oddity. It doesn't often come up. So do you use the petition date or do you make it the date that you're trying to determine what the value is worth for filing the redemption? Morales says value calculated as the petition date, not the hearing date. I tend to get a little looser with that. It's not a hard, fast rule. Objections don't arise a lot on that. I usually just say, when you file the redemption or when you're looking at filing the redemption, just pull the valuation that you're going to file the redemption with that day. Don't use a petition date because it's a little more favorable to your client. Leave it to the creditor to argue with you. Doesn't arise a lot. It's very rare that they argue about valuation date, but it can arise, so I like to point it out. So as a summary, with valuation anyway, I'd recommend you start with Kelley Blue Book, NADA, or Edmunds. You determine the vehicle's condition. I put petition date in there to be safe, but I'd probably just use it at the date you make the valuation. Take into account the retail cost of repairs or reconditioning. Like I said, has it been smoked in? Is it the windshield cracked? You know, do they have dogs that they take in it? Because that's going to involve cleaning up. You can use a client's testimony, declarations. Companies like mine will provide you with those valuations as well. So we'll provide 2 valuations. I'll go into that in a second. But so then you just determine the reasonable adjustment to the Kelley Blue Book, the NAD, or the Edmunds retail valuation. So you start with Kelley Blue Book, NAD, Edmunds, subtract those costs, and then you have that value. If you get an objection based on valuation, like I said, I always recommend, if you're working with a company, a redemption company, contact them, because typically there's some wiggle room built in, so the client might be approved for a little bit more. That would still save them money. Contact them. They might be able to up the value a little bit, could resolve the hearing or resolve the objection. The other thing is, most redemption companies can provide auction value of the car. And the reason that helps, and the reason we like to provide that is, I know it says retail costs, or what a retail merchant would charge is what the value of the car is. But creditors know at the end of the day, if the client's going to surrender the vehicle, they're just going to get the auction value. That's all they're going to end up with. So the redemption amount is typically higher than the auction amount, but it's less than what they're asking. So it's kind of in between. And you know, if you're willing to maybe offer a little bit more, that can typically resolve that. My experience was, when I was in private practice, and my experience, I guess, as counsel too, it's rare that these go to valuation hearings because typically there is room to negotiate. Typically the creditors are willing to take less because they know the alternative. But yeah, we can help with the process. Redemption companies can help with that. So attorney's fees. And this is probably the big area here most people are interested in. It's good for the clients, good for the firm. It's kind of a win-win. Well, the redemption's good for the clients. The fees are good for the firm. So you can charge a fee, as you know, for contested matters. Redemptions are contested matters. There was a big case out of Tennessee back in, that was 2004. Kind of settled. There was, you know, some debate as to whether or not you could charge a fee and then take that fee through a redemption company like ours. That case found that there was no conflict. In fact, the interests do not conflict; they coincide. It's a great case. I recommend reading it. Again, not a long read, but kind of set the standard for probably 85-90% of jurisdictions out there, including Florida. There hasn't been an issue with fees down here. So, a couple of tips though. Put in your retainer agreement that you're going to charge a fee for redemption. Charge the fee that you said put in your retainer. Don't charge more. And then file a supplemental 2016B. You know, disclose to the court. That can be necessary. What I also like, or if you do it, I think it suffices as well or works as well, is just to put it in your motion. And some forms, some jurisdictions want to see it in there, some don't. Florida, I think you typically put it in there, and there's a line. It's not it just says basically your clients have worked out an arrangement to pay the creditor within 30 days, and as part of that, they're going to pay up to $700 of attorney's fees for your work on it as well. It's a pretty basic clause. And as I mentioned, so the way the fees work through like a company like mine is, you would have your client call us or go to our website. We'll value the vehicle and see if we can help. If we can help, we offer our services. If we can't, no harm, no foul. If we can help, we'll provide you those valuations on the car, the paperwork you need to file the redemption. And then once you file that redemption, you get an order granting it. A check goes to the creditor for their amount, and then a check goes to your office for up to $700 of your fees. I have $600 in here because that's a pretty standard amount, but our lenders actually allow up to $700 of attorney's fees for redemption work. So you just have to let us know, and once you get the order granting it, check goes to the creditor, and a check goes to your office for that amount. It's also, I should mention, it's fully disclosed to the client. They have a separate trust account that they sign off on, separate disclaimer that discloses the fee. So it's in their contract. So sample motions, a couple of things to go through here. Lay out the facts. Tangible personal property, as we talked about, intended for personal use, and then describe the vehicle, year, make, model, trim, options, VIN, mileage, condition, and then go through the valuation, as I mentioned. What's the basis for it? What's the retail starting point? What are the retail cost of repairs? Mention it's a dischargeable consumer debt. It's part of the code. I like to mention that you'll pay the old creditor within 30 days. It's kind of the baseline or the standard. And then this is a big one that if it's a bank or credit union, make sure you serve the highest ranking officer or official. And we see this a lot. If you don't, either the judge can throw it out or the creditor can come back and later say they weren't properly served on it. I don't have the section of the code right in front of me, but it requires you to serve the highest ranking officer or official of a bank or credit union for redemptions. I see this a lot, unfortunately. I've seen it where we've had a redemption funded and done for, well, we thought funded and done for over a month, and then the creditor comes back and says, we were never properly served. We didn't have any notice of this. And I'm sure you guys have experienced it in other areas as well, not just this. So always make sure that language is in there. And then, have the order mirror the motion. A couple other practice tips. Double check there are no other lien holders on the vehicle. I didn't even know these existed actually until I joined 722. But this happens to us. Again, kind of like the service issue, happens more than well, at least once a month probably, so not that many times, but enough that it's a headache for me. Basically, we're notified by the client that there's one lien holder on it, and we don't verify the title. We don't look at the title. We kind of rely on the attorney. We rely on the client for that. So we think, okay, Capital One's the only lien holder. Well, lo and behold, they took out some finance loan or some personal payday loan, and they're put a lien on their vehicle too, and the client didn't even remember it or think about it or know about it. And so we file the redemption, we get that order granting it, we get the title, and then we see our finance company gets the title, and then they see, well, who's this other lien holder? There's no clean title, there's no clear title. Now they have the first lien on it, actually. And they're not going to do anything about it. They're not going to enforce it, but they won't release it. These secondary lien holders will not release it.
Steve, to look for that, where would you go? The DMV to see the
DMV.
title, the UCC?
I'd go DMV, yeah. And I think they're online titles here, is that correct? Yeah. So I would go on there and look. It like I said, it only rises about once a month. I see it, but that's more than enough. And it's the easiest thing to correct in a motion. So you file the motion to redeem. You list Cap 1 as getting $10,000 for the car, and then you list whatever payday loan company is getting $1 for the car. And we have a language we can provide you, but it basically says they have no interest in the vehicle. The car is only worth $10,000. Credit Capital One's getting that $10,000. We'll give you $1, and it works every time. It just, you have to do it up front, Otherwise, then it becomes you got to go file a second motion to redeem, listing that secondary credit, or file an amended motion to redeem. It's just a lot more work, a lot more headache, and the case might not even be open at that point. Prepare for objections. Like I said, look around, talk to, if you're working with a company like ours, talk to us, see if there's wiggle room, see if we can help. Because if they object, it will be because of value. I mean, that's going to be the big objection. Usually there are some room for settlement. Again, a basic rule, but double check you have the right creditor listed and the right address listed, basic stuff, but it arises. I mean, you'll be surprised. And I like to put what to look for in a lender. We've been around for over 25 years. We used to work solely with U.S. Bank, National Bank, obviously. We work with multiple lenders now. And the reason was U.S. Bank was a little more stringent in the fact that if you had a U.S. Bank loan and you were filing bankruptcy, they wouldn't allow redemption. You couldn't redeem a vehicle using them as the finance company if you were also filing bankruptcy against one of their debts. What's the level of expertise? Who are you working with? Are you talking to a real person? Do they know what they're doing? Again, just general, any hidden costs. And then everything should be disclosed up front. I mean, I think with the changing laws over the past few years and with just, from a business standpoint, and I think most companies that work in finance and work with bankruptcy attorneys, we kind of like to say, we wouldn't have survived 25 years if we weren't providing a benefit to clients. And I think that's the case for most companies that do it. From the simple standpoint, attorneys, our majority of our business is attorney referral. We do no marketing to clients, there's nothing like that. We just work with attorneys. So if we weren't helping or providing some benefit, I think we would have been run out of the bankruptcy industry. I will mention a couple other programs as well beyond the redemption, so beyond the scope. And again, if you have any questions, feel free to jump in. But trustee funding, what's the exemption amount here for automobiles or for personal property? Is it decent? Is it
$1,000 on an automobile.
1,000?
Yeah.
Ooh, that's pretty low, it sounds like. Or do you have a wild card then?
Yeah.
Okay, so that makes up.
Depends
All
on the
depends.
house or not.
It depends if you have a homestead or not. You might get the wild card, you might not get the wild card.
Okay. Well, we offer, then this might actually be beneficial. Some states, with better exemptions, it doesn't help. But so the trustee funding program is kind of the opposite of the redemption. That's where the client has too much equity in the vehicle. So grandma bought them a car, or they can't exempt all their equity for some reason or another, and the trustee is going to administer that vehicle as an asset. We can provide funding for the client to keep their vehicle. So if the trustee is going to go after that $10,000 car and try and auction the car, we can actually provide the client the $10,000 to pay off the trustee if they wanted to keep it.
Steve, do you just do that with vehicles, or do you do it with personal property?
Just automobiles. Yeah, good question. So the couple of benefits, obviously, is the client keeps their vehicle. Reestablish credit, obviously, if they're financing it. And then typically what we've seen is the trustees are happier with this arrangement. One, they avoid the cost of the sale and the auction and the hassle of all that. And two, they're getting a lump sum check for the car. So they're getting paid right away rather than maybe they were trying to take payments from the client or something like that. Or I don't know how some of the trustees do payment plans and some of them now don't. So it's a good mix there. But in this scenario, they get paid right away. And then finally, we also offer replacement vehicles. And I mentioned a backup plan earlier when I was discussing redemptions. This is kind of where the replacement program came out of. So if you have a client that was trying to redeem a vehicle and maybe the creditor is just going to fight it, or the redemption's not going to go through, or maybe they just decide they don't want to keep that vehicle, we can also provide funding for them to get a replacement vehicle as well. So if they want a different vehicle, we can help them with that. The way the replacement program works is they can get approval before filing. Same with the redemption. You just have them call us, and we'll give them an approval or let them know if they qualify. And then day one of filing, they can actually get a replacement vehicle. And they can go about that one of two ways. Like I said, you can have them call us or go to our website. And they can we work with a nationwide dealership. We're based in Cincinnati. I know another gentleman's from there. But we can either, they can get a vehicle through the nationwide dealership we work with in Cincinnati, or they can get a vehicle from a franchise dealership here. The main rule is it just has to be a franchise dealership. We don't work with buy here, pay here's. We don't work with, old closed down or old Saturn dealerships or whatever they may be. It has to be a franchise dealership, so like a Chevy, a Toyota, a Ford, something like that.
Steve, what was that, the number that they call? Your number?
Yes, yeah, and it is 888-721-2800,
Thank you.
and or our website 722redemption.com.
722redemption.com.
Yes.
Okay.
There are fees also available with the replacement program. Some attorneys take them, some don't. So the way that works is if you're helping the client, you're going to review the contract, or you think you've earned a fee. Our lenders do allow up to $300 of attorney's fees for your work on a replacement. So it'd be the same as a redemption. You just get a check for it once they sign the contract. That kind of started based on, as I mentioned, if there was a failed redemption. So if the redemption doesn't go through and the client needs a different vehicle and needs a replacement, we offered replacement fees as kind of a backup since you wouldn't get the fees on
What's the interest rate?
that'll go as low as 10% as well. I think the highest is around 18 on that. Now that should be, whatever our replacement rate is, should be very market competitive because we work with the same lenders that the dealerships work with. So we're going to find, or we're going to be able to find the best rate for the client. The benefit, I think the biggest benefit of our replacement program is the client doesn't have the add-ons that they would get at a dealership. So we don't sell them the rust proofing. We don't sell them the worthless add-on products. So if they work with like the dealership, the nationwide one in Cincinnati, so they would call us, and then if they found a car through that dealership online, it would be shipped to them. They're still not under any obligation. They can drive it around, try it. If they don't like it, they can ship it back. I think that happens once every 3 years, really. It doesn't happen very often, but they can do that.
Are these new cars or used?
Both. It can be both, actually. They will have factory warranties, though, because they're all new model cars.
Steve, they have, you said there's a lockup agreement. By the time they file the case, it's a definite, they won't be thrown out of the program or anything like that. You can guarantee that they'll get funding for this vehicle, once the case is filed, essentially.
I can pretty much guarantee it. I mean, if they lose their job or if they, circumstances change, I can't. But as long as nothing changes, because our lenders know they're going to be filing bankruptcy. They know, okay, then they're surrendering their old car. So they know all the facts and they know their income. And as long as nothing, there's no, oh, I lost my job 2 days after filing.
Okay.
Yeah. But that would happen, with pretty much
Sure.
anything. We also offer replacement funding for post-confirmation 13s. So if a client needs a vehicle and their other one goes out on them, has to be post-confirmation, but we can provide funding for that as well. But those are kind of our big programs. Does anybody have any questions? I don't have my watch on me, so I don't know how long I ran, if I got close.
You're perfectly on time, Steve.
Oh, sweet. Any
Thanks.
Thank you, guys. And feel free. I had a pretty hectic travel days, but I'm the only attorney at 722. So if you have any questions, just call. They can put you through to me. So yeah, I'm happy to walk you through the process. But I didn't bring any cards, but yeah, feel free. We actually just moved locations anyway, so they're not accurate anymore. So, but yeah, feel free to reach out to me directly.
Thank you very much, Steve.
Thank you.
Everyone, Mr. Lynn has graciously volunteered to video this, so this will be available online, and I'm going to be sending out a blast email. Mr. Rivera had given me the CLE code for the last presentation that was made last month, and we did apply for CLE credit for this one, but sometimes the bar's a little slow, so if we do get approval, I'll also send that out as well. I don't have any announcements, except that we do have a speaker for next month, and then if everyone could check their emails for Mr. Trunkett's blast email for the upcoming judges' dinner in October. Thank you.